Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book from Oxford University Press. It's called Millington and Sutherland Williams on the Proceeds of Crime, and it's now in its third edition. It's this red top book here, if you like. It's 750 odd pages. You can see the sort of index at the back. The bulk of the book is nicely structured with paragraph numbers at the sides and some footnotes at the bottom, and you've got a useful set of chapters at the front. One thing I do like is with the individual chapters is you actually have a short analysis of what they're about, because this is not an easy piece of legislation to understand. Obviously the case law is very substantial. There's a web article and various appreciations from us, and there's the Flickr article which Elizabeth and I have written. We've given it the title, Trying to Find a Way Through This Complex and Over-Engineered Legislation. Well, if that's the case, then use this well-organised and comprehensive guide, because you do need something like this to help you. I believe it's a great legal helpmate both for judges and lawyers alike, because it rises to the challenges of the legislation we're now confronted with when trying to interpret and apply statutes in a way which Lord Justice Toulson in his Foreword suggests must be loyal to the language of the Act and at the same time be just and coherent. So therefore it's important to get it right, because the new coalition government clearly sees this area of criminal sanction to be a future important mechanism in the fight against organised crime. Now, Millington and Sutherland Williams start with the question, why was confiscation law enacted? And very quickly we get to the controversial nub of the issue: drugs and international money laundering. It's a bit like policing the internet, really. Until there's a proper international agreement, which is doubtful, the serious problems will remain concerning the current neutered approach by the key law enforcement agencies towards attempts by defendants to retain ill-gotten gains. What the authors have achieved, we feel, is a weighty consideration of the current legislation against a backdrop of the practical problems which both defence and prosecution counsel face when interpreting and implementing successive parliaments' wishes. The third edition addresses the confiscation and restraint of proceeds of crime in a particularly interesting way. It's a tall order, but we think Millington and Sutherland Williams rise to the task very well indeed. We're interested also to see the reaction of Toulson to the subject matter when he describes it as the bête noire for Crown Court judges. His suggestion that depriving criminals of the proceeds of their crimes could have been approached in a simpler way by setting out the basic structure of the confiscation regime and establishing general principles with the courts left to work out the practicalities is eminently sensible. In fact, far too sensible for parliamentarians, of course. Now, it may well be that Parliament may revisit this within the next 5 years. Meanwhile, we've got an invaluable service here from the authors giving us explanations which we need. Mr. Justice Kay, now Lord Justice Kay, stated in the first edition that crime can be extremely profitable, so striking a balance between the need to ensure that criminals do not prosper whilst giving the guarantee of fair treatment for defendants and third parties is what we need. Therefore, Millington and Sutherland Williams have performed what David Perry, Queen's Counsel, describes in the second edition as an invaluable service in the explanation of how we deal with the proceeds of crime successfully. But there is much work still to be done, of course, before crime is no longer extremely profitable. This book is a start. Thank you very much to all concerned. Bye-bye.